Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching.
I was built to last when the webs are weaving. I could change the past with all I'm achieving. Got my foot on the gas, never stop competing. If you break like glass, then this life's coming.
I wanna be the best in the game, invest in my name. Check no restraints, I'm obsessed with the pain. I ingest, I retain, assess and I change. Possessed by the thought I'll be free one day from society's
Today, we're taking a closer look at a really profoundly tragic OWI homicide case. It happened in Waukesha, Wisconsin.
Yeah.
And our mission here isn't just to, recount the awful facts, but to really unpack how the justice system handles something so emotionally charged while still making sure due process is followed.
Exactly. This situation gives us a pretty stark look at the devastating results of reckless choices, but also the methodical work the legal system has to do in response.
It really does.
It's this tough balance between accountability and protecting everyone's rights.
Okay, so let's set the scene. December 30th, 2024. East Sunset Drive and Guthrie Road. There's this awful multi-vehicle crash. And sadly, 17-year-old Megan Voss lost her life. The driver of the pickup truck, Jason Zehe, who was 19 at the time, was going incredibly fast, blew right through a stop sign, and T-boned Megan's car. Just absolutely devastating.
And what's really concerning, I think, is Zehe's history before this, even at his young age.
Right. Tell us about that.
Well, just 8 months earlier, April 2024, he was 18. He gets cited for OWI after crashing another vehicle.
Okay.
But that charge, it was dismissed. The reasoning was because it happened on private property. And prosecutors apparently stated back then that he does not appear to pose an ongoing danger.
Wow. That's hard to hear now.
It really is. Especially when you add in, he also had a speeding ticket, like 98 mile per hour in a 45 zone.
98 and a 45.
Yeah. So these earlier incidents, they sort of paint a picture, don't they?
They really do.
Yeah.
And then you hear about the environment. Z told investigators he'd been getting drunk at his girlfriend's family home since he was 15.
Suk's 15.
Yeah, and reportedly her mother was supplying the alcohol. On the night of the crash itself, he admitted to drinking wine and vodka for maybe up to 8 hours.
8 hours.
His BAC, the blood alcohol concentration, was about 0.24.
Which is what, 3 times the legal limit?
3 times Wisconsin's limit of 0.08.
Yeah.
The DA put it very bluntly. He said he did not have the right of way. He did not slow down. Literally, it was as if he had a gun in his hand.
That's a stark comparison.
And the victim had very little chance of surviving.
Just chills.
It really is. And then there's Megan Voss. We need to talk about her. A 17-year-old senior, Waukesha West High School, getting ready to graduate in the spring.
Yeah.
Just vibrant, a cheerleader, involved in all these clubs, random acts of kindness, Bible club, mentoring. Just seemed like a wonderful kid.
Inspiring nurse, too, right? Doing well in a healthcare co-op already.
Exactly. Friends said she always put everyone else first. And just adding to the heartbreak, her family's dog, Blue, was in the car too.
Oh, no.
Critically injured, had to be euthanized later. It's just layer upon layer of sadness.
And that really brings up, how does a community even begin to cope with something like this?
Right?
Waukesha really came together. You saw spontaneous memorials, grief counseling at the school.
The Culver's fundraiser, too. I read about that.
Oh, yeah, massive. Aiming for $20,000 for the family. The lines were apparently wrapped around the building. It just shows you the depth of the community's grief.
Definitely. And you saw that grief and also, frankly, outrage reflected online and in local news. Lots of calls for tougher OWI laws.
Understandably.
People asking, could this have been prevented? Especially questioning that dismissed OWI charge and Wisconsin's sort of unique approach where a first offense, OWI, is a non-criminal violation.
That's a tough question. That private property dismissal looms large in hindsight.
So legally, what happened next? Zehe was charged pretty quickly, right?
Yes. 4 felonies, 3 misdemeanors. The big ones were homicide by intoxicated use of a vehicle that's a Class D felony, could mean up to 25 years.
Okay.
And second-degree recklessly endangering safety, bail was set high, $250,000. He stayed in custody.
So even with all the public emotion, the system had to work.
Absolutely. And that's what you see here. Due process, even in the face of immense tragedy. The court made sure he had lawyers, followed all the steps.
And it didn't go to a full trial.
No. On August 21st, 2025, Zehe pleaded guilty, part of a plea agreement. He pleaded to the 2 most serious felonies, the homicide and endangering safety charges. Other charges were dismissed as part of that deal.
Which likely spared the family the trauma of a trial.
Exactly. It allowed for a measure of justice without prolonging that agony.
So this deep dive, it really highlights this tension, doesn't it?
It absolutely does. It underscores how the justice system has to try and balance holding people accountable for truly devastating actions with, carefully preserving rights and following procedure.
Yeah.
It's never easy.
No, it's not. And it leaves us, and you listening, with a really provocative thought, I think. Given the details here that Pryor dismissed OWI, Wisconsin's specific first offense law, what role do these state laws actually play? Do they deter this kind of behavior, or could they maybe inadvertently enable patterns of recklessness that lead to such awful outcomes?
That's something definitely worth considering as you reflect on this story.
Just now, I haven't looked at those, but I think that's going to be referred to by one or both of you. I don't know, so I'll wait on that. Will you recite the negotiations, please, Ms. Basie?
Your Honor. For a plea to count 1, which is the OWI homicide, and count 4, which is the second-degree recklessly endangering safety, the state would dismiss and read in the remaining counts.
Except for 7?
7 would be dismissed by operation of the law.
Yep.
The state on the OWI homicide will be recommended.
Hang on a second. Is there anybody by Zoom?
Oh, yes. I'm sorry.
Okay. Just let me know when they're connected. This is Judge Ebrahimian. I just called the case and we saw that you just joined. Can you hear me okay? Just give me a thumbs up if you can, or you can unmute and let me know. Julie, can you hear me? Julie, can you hear me? It looks like you froze.
Yes, I can hear you now, thank you.
All right. You can go ahead and mute yourself until if and when you're going to say anything, okay? Ms. Basie, if you want to recite the negotiations, please.
Thank you, Your Honor. For a plea to counts 1 and 4, which is the OWI homicide plus the secondary recklessly endangering safety, counts 2, 3, 5, and 6 would be dismissed and read in. Count 7, which is the PAC homicide, would be dismissed by operation of the law. On count 1, the OWI homicide, the state is recommending 10 years initial term of confinement, followed by 10 years of extended supervision. On count 4, the state is asking the court to impose 3 years initial term of confinement, followed by 3 years of extended supervision, consecutive to the prison being recommended on count 1. We're asking the court to stay that sentence and place the defendant on probation for 5 years consecutive to the prison sentence in count 1. As conditions of probation and extended supervision, we're asking the court to order an alcohol and other drug assessment and follow through with any recommended treatment, absolute sobriety, no presence on a premise that serves alcohol by the glass, no use or possession of any controlled substances without a valid doctor's prescription, no use or possession of any CBD product, no use or possession of drug paraphernalia, random alcohol and drug screens. He's to have no contact with any known drug users, no contact with any member of victim A's family, no contact with victim B or any member of her family, no contact with victim C, criminal thinking course, any assessments or counseling deemed appropriate. He's not to operate a motor vehicle unless properly licensed, full-time employment and or schooling or a combination of them both. Restitution is $12,077.09, payable to crime victim compensation. We're asking for 8 hours of community service to be served on December 30th of each year while on extended supervision as well as probation. Court costs, DNA sample and surcharge, and any other conditions deemed appropriate by the court.
Is that an accurate recitation of the negotiations, Mr. Steinle?
Yes, and I did. Those exact words I attach as an attachment to the plea questionnaire.
All right, Mr. Zehe, raise your right hand and get sworn in, please.
Do you swear the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Zehe, you heard the discussion between the two attorneys regarding a potential resolution of this matter?
Yes.
And have you had enough time to discuss the advantages and disadvantages of the plea agreement with your attorney?
Yes, sir.
You understand that I'm not bound by the recommendation of either attorney.
Yes, sir.
And if you were to change your plea today to counts 1 and 4, I'm going to find you guilty of those counts, hold you accountable, and you'd be taking your chances with me at sentencing. Do you understand that?
Yes, sir.
Have you had an opportunity to review the complaint as well as the amended information in this case?
Yes, sir.
Are they substantially true and correct?
Yes, sir.
As I understand the negotiations, you're going to be changing your pleas today to counts 1 and 4. Count 7 would be dismissed by operation of law, and counts 2, 3, 5, and 6 would be dismissed and read in.
Yes, sir.
What that means is you would not have to plead guilty or no contest to those counts. As a matter of fact, they would be dismissed. You wouldn't suffer any potential fines or any potential incarceration relating to those counts. However, I can hold you accountable for that conduct when I do decide to impose the appropriate sentence on the 2 counts to which you would be changing your plea today. Do you understand that?
Yes, sir.
Let's focus then on those 2 counts. There's an amended information. We're going to put that on the screen here. And you can follow along. Mr. Zehe, it does allege that on or about Monday, December 30th of 2024, in the area of East Sunset Drive and Guthrie Road in the city of Waukesha County, Wisconsin, you did cause the death of victim A by the operation of a vehicle while under the influence of an intoxicant. That's contrary to Wisconsin law. It's a Class D felony, and upon conviction may be fined not more than $100,000, or imprisoned not more than 25 years, or both. Do you understand that?
Yes, sir.
I have a plea question and waiver of rights for. We're going to spend some more time on that in a moment. Attached and filed along with it is not only the offer that was put on the record a few moments ago that Mr. Steinle referred to, but also the jury instructions. And for homicide by operation of a vehicle while under the influence, it identifies the elements to this offense, what the state would have to prove beyond a reasonable doubt to find you guilty of this charge, and it appears to have your signature on the bottom. Did you review these elements with your attorney?
Yes, sir.
Did he explain them to you?
Yes, sir.
Did he also explain to you the potential consequences of pleading guilty or no contest to this charge?
Yes, sir.
That you could be fined up to $100,000 and incarcerated in prison for 25 years. Do you understand that?
Yes, sir.
Do you understand that your operating privileges would be revoked for up to 5 years?
Yes, sir.
And that with respect to your imprisonment, there's a presumptive minimum of 5 years in prison. Do you understand that?
Yes, sir.
You also understand that this is a felony, and if convicted of this felony, will not be able to use or possess a firearm in the future, and will not be able to vote in any elections unless and until your civil rights are restored.
Yes, sir.
You also understand that if I enter a judgment of conviction on this count, I'll be imposing court costs as well as a DNA surcharge.
Yes, sir.
Given that understanding, how do you wish to plead to count 1?
Guilty.
Let's look at count 4. Again, it is second-degree recklessly endangering safety. And again, you can follow along. It's on the screen. It does allege that on or about Monday, December 30th of 2024, in the area of East Sunset Drive and Guthrie Road in the city of Waukesha, Waukesha County, Wisconsin, you did recklessly endanger the safety of victim C. That's contrary to Wisconsin law. It's a Class G felony, and upon conviction may be fined not more than $25,000 or imprisoned not more than 10 years, or both. Do you understand that?
Yes, sir.
Again, attached to the plea question and waiver of rights form is the jury instruction for this cause of action. And again, it's jury instruction 1347. It's on the screen in front of you, and it identifies the elements to this offense, what the state would have to prove beyond a reasonable doubt to find you guilty of this charge. Did you review these elements with your attorney as well?
Yes, sir.
Did he explain them to you?
Yes, sir.
Did he also explain to you the potential consequences of pleading guilty to this charge?
Yes, sir.
That in addition to all the fines, incarceration, revocation, costs, and DNA surcharge you would face on count 1, you could face an additional $25,000 fine, an additional 10 years in prison, additional court costs, and an additional DNA surcharge. Do you understand that?
Yes, sir.
Do you understand that, like count 1, count 4 is a felony, and if convicted of this felony, would not be able to use or possess a firearm in the future, and would not be able to vote in any elections unless and until your civil rights are restored? Do you understand that?
Yes, sir.
Given that understanding, how do you wish to plead to count 4?
Guilty.
All right, these are important decisions, Mr. Zehe. I want to make sure you're making them freely, voluntarily, and intelligently. I have a copy of the plea question and waiver of rights form you completed with your attorney. I think he just gave you a copy. There's a copy on the screen here, so whichever one is easier for you to follow along, you can follow along. Right below defendant's statement, it says, I have reviewed and understand this entire document and any attachments. I reviewed it with my attorney. I have answered all questions truthfully, and either I or my attorney have checked the boxes. I'm asking the court to accept my plea and find me guilty. Is that true?
Yes, sir.
And is that your signature on the document?
Yes, sir.
And it's dated August 14th of 2025, which is about a week ago. Is that when you signed it?
Yes.
Did you review the entire document before you signed it?
Yes, sir.
Did you understand it?
Yep.
Did you review it with Mr. Steinle?
You reviewed it?
Oh, yes. Yes, sir.
And was he able to answer any questions you had relating to it?
Yes, sir.
If you go to the first page of the document, Mr. Zehe, it says you are 19 years old and have completed 12 years of schooling, that you have a high school diploma or equivalent, that you understand the English language, and you understand the charges to which you're pleading. Is all that true?
Yes, sir.
It says you are not currently receiving treatment for a mental illness or disorder. Is that true?
Yes, sir.
And it says you have not had any alcohol, medications, or drugs within the last 24 hours. Is that true?
Yes, sir.
That may have been true on August 14th when you signed it. Is it still true today?
Yes.
It's an important question. I want to make sure you're thinking clearly, that you're not impaired in any way when you make this important decision. If you look at the next section of the document, Mr. Zehe, it says constitutional rights, and it identifies the various constitutional rights you're giving up by pleading guilty to these two charges. And on the version of the document I have, all the boxes have been checked. Did you review these constitutional rights with your attorney?
Yes, sir.
Did he explain them to you?
Yes, sir.
Do you understand you're giving up the right to a trial? And as it indicates later on the same section, it's a jury trial where all 12 jurors would have to agree. That you're giving up the right to remain silent, and you understand that your silence cannot be used against you at trial. You're giving up the right to testify and present evidence at trial. You're giving up the right to use subpoenas to require witnesses to come to court and testify for you at trial. You're giving up the right to confront in court the people who testify against you and to cross-examine them. And you're giving up the right to make the state prove you guilty beyond a reasonable doubt. You understand you're giving up each and every one of these important constitutional rights by pleading guilty to these two charges.
Yes, sir.
Do you have any questions of me relative to the rights that you're giving up?
No.
Has anyone threatened you to get you to plead guilty and give up these rights?
No, sir.
Other than the plea agreement, has anyone made any promises to you to get you to plead guilty and give up these rights?
No, sir.
Do you understand that if you are not a citizen of the United States of America, that a plea of guilty or no contest for the offense with which you are charged may result in deportation, the exclusion from admission to this country, or the denial of naturalization under federal law?
Yes, sir.
Are you satisfied with the representation you received from your attorney on this matter?
Yes, sir.
Are you at all confused about anything you're doing here today?
No.
Do you have any questions for me?
No, sir.
Mr. Stein, you reviewed the plea questionnaire and waiver of rights form with Mr. Zehe.
I did, Your Honor.
Are you satisfied that he understands the elements of the offenses and the maximum possible penalties that could be imposed upon him?
Yes, Judge.
Satisfied he understands all the rights he's giving up by pleading guilty to these two charges?
Yes, Judge.
And satisfied that his pleas of guilty are made freely, voluntarily, and intelligently?
I am so satisfied.
Based on the foregoing discussion, I'm approving the waiver of rights. I find that Mr. Zehe's pleas of guilty are made freely, voluntarily, and intelligently with a full understanding of the nature of the charges, his conduct, and the maximum possible penalties that could be imposed by law. State offering the factual allegations in the criminal complaint and the amended information as a factual basis for the charges.
We are, Your Honor.
Any objection?
No, Judge, but the person on Zoom is no longer there.
Did it just...
I didn't mean to interrupt you.
No, that's fine.
Yeah, I didn't want to have to.
They're still there. We had a... Ms. Voss, you've been hearing everything, correct? Okay, we were showing a document before, and then when we came back, you weren't there, so. Court finds there's a factual basis for the acceptance of your pleas, and based on those pleas, the court now finds you guilty. The offenses in a manner and form charged in the amended information. I will dismiss count 7 by operation of law and dismiss and read on counts 2, 3, 5, and 6. Sentencing, again, you've complied with victims' rights.
We have.
All right, go ahead.
Thank you. Yeah, first I'm going to tell the court a little bit about the crime and the information that was garnered after December 30th of last year. On that day, Megan was at home, and I did get permission from Megan's family to use her name instead of the victim A label. I think they want people to know that she lived and she existed. So Megan was at home. She was at home with her dad, who's in court today, as well as their dog, Blue. Troy, as the dad, was to pick up his son, and he was feeling kind of tired. He'd got up early that morning, so Megan agreed that instead of him going, that she would actually go with Blue and pick up her brother at a restaurant in Waukesha on Sunset Drive. Megan was driving northbound on Guthrie Road. If you know the intersection, it's Guthrie and Sunset Drive, which is where this happened. She was northbound on Guthrie. She was turning to go onto Sunset Drive towards the city of Waukesha. There's a 4-way stop sign at that location, and I do have Exhibit 2 up on the screen to give the court some perspective of this area. So Megan's car is in the right side going from the right to the left. The defendant's truck is on the left side going from left to right. At that time, I'm sorry, that is not true. Megan's car was going from bottom to top.
You confused me there for a second when you said right.
Yes, I'm going to start over. So Megan's car is going northbound on Guthrie, turning westbound on Sunset Drive. Her car is in this picture. The defendant's truck, which is the white vehicle, is impacting her car at that time. He's going eastbound on Sunset Drive. The other car, which is labeled the Toyota, that's where there's four-way stop signs at that location. That's victim C. Victim C was stopped at that location to proceed westbound on Sunset Drive. So as Megan is turning to go left and essentially westbound on Sunset Drive, the defendant, after she had stopped, victim C says she stopped, it was her turn to go. She starts going and the defendant crashes into her. I know that Attorney Steinley provided a picture from the scene with his packet of information showing some skid marks. Although I think that's relevant, I would note that they were started fairly late, and the impact when the defendant hit Megan's car, he was going 66 miles per hour, which means when he applied his brakes, he was going way over 66 miles per hour. I can also tell the court that the speed limit on that road is 30 miles per hour. I think that gives some perspective. So what happens is in this picture, which is again exhibit number 3, I believe, is what's happening in this picture or this diagram is Megan's car again is the Audi, so she's in the top car on the picture. Victim C's car is again, it's the Toyota, and then the defendant's vehicle, when it smashed in, it actually hit victim C's vehicle, flipped over, and ended up in back of victim C. And that's all I need for that. Thank you. But just to give the court some perspective of that area. One of the drivers gets out of the car, goes to the defendant's truck. Victim B, which is his then girlfriend, was kind of hanging out of the truck. The defendant indicated immediately that it was his fault, so he did accept responsibility at that time. Although I would note is when law enforcement was asking him if he had drank anything or used any drugs, he vehemently denied either. Blue, they were having a hard time getting Blue out of the car. Obviously the car, they had to use Jaws for life to get both Megan and Blue out of the car. They were able to get Blue out of the car. However, he was unable to be approached because he was going to bite anyone who approached him until Megan's dad arrived. At that time, I believe Megan had been extricated from the vehicle. They were driving her to Meyer to where Fight for Life was going to meet them to take her to Frederick. Troy then had a tough choice. Blue was actually his support dog and was one of Megan's best friends. Troy, because no one else could get near Blue because he clearly had 4 broken legs. He was in a severe amount of pain. He took him to the emergency vet. He pretty much left him there because he wanted to get to Frederick to be with Megan. The accident occurred around 7, I don't even want to say accident, I want to say collision occurred around 7:30. Megan was pronounced dead at 9:07. They do believe that she was kept alive to some extent because of the pressure of the car on her body was actually preventing the blood to be released. Then the defendant is also transported to the hospital. Law enforcement again makes contact with him at the hospital. When they again asked him if he had been drinking or using drugs, the defendant said he had 2 drinks. He denied using drugs. When they asked him where he thought he was when the crash occurred, he thought he was between McGuanago and Big Bend. Obviously, he had no idea where he was. When the defendant was told at the hospital that Megan had succumbed to her injuries, the defendant said, I should be going for life. I took a life. And I think that's very consistent with his acceptance of responsibility in terms of a very quick plea when you look at the nature of the charge. Him telling the citizen witness who went up to him when the crash happened, saying this was my fault. So certainly that's something that the court should take into consideration. I can also tell you that the defendant agreed to meet with the attorney for Megan's estate. He gave a full statement with regard to the history of him, and that statement was included by Attorney Steinley to the court, a full history of the defendant going over to victim B's parents' house Thomas and Hermelina's, Hermelina's residence, and drinking, I believe he estimated it was over 100 times before December 30th of last year. And he provided that information, and Attorney Stanley approached me and indicated he'd be willing to provide that information early on. So certainly that also shows a level of taking responsibility and being willing to cooperate, which was appreciated. Victim B, her PBT was a .179. To kind of go, I told you a little bit about Megan's perspective. This defendant had gone over to his girlfriend's residence. He had drank. As a matter of fact, he took off of work. He called in sick, went over to her residence. They were drinking together. At one point, he believed that Victim B's mother supplied them additional alcohol. And at some point, Victim B's dad came home. He was very upset that the defendant and his daughter were drunk. So he ordered the defendant to leave. The defendant did leave the location of the residence. Victim B was calling or texting him to come back to pick her up because she wanted to leave. He went back, picked her up, and then they began to go presumably towards his house, although the direction that he took wasn't what you would normally think you would take if you were sober. In looking at the Southhawk information from the defendant's phone, they went into the Target parking lot. They were driving around the Target parking lot. So they were just really all over the place. And then obviously the collision occurred. I went to Megan's funeral, and it was one of the most interesting funerals I've ever gone to because obviously her peers decided at 17 that they wanted to speak and tell their story of Megan and what Megan meant to them. And I know that the court has received various letters from her friends, her schoolmates, and I'm not going to talk as much about Megan because I think I didn't know Megan. I only know her through these stories and through talking to her dad and her brother. I think those letters really say it all. And I know that there are 3 people, I believe, today that would like to speak as well. We did get a lot of calls regarding charging Victim B's parents. I think the community was very upset. No decision has been made at this time what is going to happen with that case and with the charges will be forthcoming. Certainly we are continuing to gather evidence. So although I say the defendant accepted responsibility, and I think he should be given credit for that Megan's family, Victim C and Victim B do not have to go through a trial, in the end it was the defendant's decision to drive that night that caused Megan's death. I read a letter that was submitted by Attorney Stanley by an individual identified as Mary Briski, B-R-I-S-K-I. In that letter, she indicates because of a short lapse in judgment, that the defendant had a short lapse in judgment. And I disagree with that because when I look at the defendant's character, I look at some of his other driving in 2024. And I'll kind of go sequentially. On February 5th, 2024, in the area of Victim B's residence, the neighbor heard a car that she identified as a silver Honda Civic, which was the defendant's vehicle. He was coming out of their driveway, tires were screeching, he was driving very fast. When he hit the roadway, he looked like the vehicle was out of control. She was so concerned that she emailed the Sutners, Victim B's parents, and said, this is not acceptable in our residential neighborhood, this type of driving, this speed, and that was February 5th of 2024. Later that day, the same neighbor stated that she saw the defendant's car in a cornfield right down the road with damage to the bumper. It appeared that the vehicle had gone off the road into the farm field, and it was there for a couple days before it was towed to the Sutner's residence. So that's February 5th. On February 18th, this neighbor indicated that victim B's mother and father, Tom and Hermelinda, were outside in their driveway in a truck, and that the defendant, again, was outside of his silver Honda Civic. There was a lot of yelling. The settlers were told yelling at the defendant to leave, which he subsequently did leave. And then we have April 4th, 2024, and this is a case in which the defendant, the police were called, I believe, by a neighbor. The defendant, that same silver Honda Civic, was crashed into a pillar at the settler's residence. It basically towed the car, and I do have a picture of that to show the court. That's also been marked as Exhibit 1. Basically, as the deputies went there, they observed that they believed the car was coming into the driveway, lost control, and crashed into the pillar, which it was a very big pillar, and obviously he crashed into it, totaled his car, and the pillar was pretty much scattered all over the yard. He was cited based upon the belief that he had operated on the roadway, turned into the driveway. He was cited with an OWI. His, not PBT, his intoxicating result was a .17. Later on, he did retain an attorney, and the attorney did file affidavits from both victim B as well as victim B's mother, pretty much indicating that the defendant had been drinking at their residence, that in fact victim B had been giving him alcohol, and the father was about to come home, and the mother wanted him to leave so that the father would not see that he was at their house drinking. So they ordered him to leave, and as he indicated in the transcript, he was driving out, lost control of the car, and that's when he smashed into the pillar. As a result of the affidavits, the state did move to dismiss the OWI because we didn't think we could prove operation on the roadway. So when we say that this was a lapse of judgment, and why I bring up those instances, is this wasn't a one-off incident. December 30th was accumulation of all these incidents building up. Here, he totaled his car, he was a .17, and he was drunk. He knew. This is a rural area. If they had ordered him to leave on December 30th, which I don't doubt that they did, he could have pulled over the side of the road and not driven the car any further. Instead, he decided to drive his car. He was a .9, thank you. Obviously very drunk. So when I look at the character of the defendant, I have to look at that. Again, he did accept responsibility. His exposure in just these 2 counts is significant. It is 20 years initial term of confinement followed by 15 years of extended supervision. This was a case I had met with Megan's dad and her brother, as well as other family members throughout the pendency of this case, and I asked them, what would you like to see? And I think Megan was a very strong Christian girl, and I think that she got that from her family. And they said they didn't want to ruin this defendant's life, even though he had ruined theirs. And they believed, in talking to her mom, her dad, and her brother, that this recommendation would be appropriate. That he should serve time, but he should have the opportunity to also do good once he is released from prison. And I think that coincides with the defendant's own statement to the court as to his wishes and how this has impacted him. And I think that's helpful, and I think it'll be helpful for the family to see that he does take this seriously. And Attorney Steinley at all times has said how remorseful the defendant is, and I think that certainly entered into their decision as to what should be recommended. We have, you have the victim impact statements from a number of people. There are 3 people present. I think originally we thought there'd be 5 victim impact statements done in court. Both Megan's dad and her brother have elected not to speak. What they said is that they expect that the court will do the right thing and that they're leaving it in God's hands. And they also stated that they could never put into words what Megan meant to them. And they know that she knows how much she meant to them, and that's what's important for them. I do have victim A, so Megan's grandmother here, that she would like to give a verbal victim impact statement. And her name is Lynn, Lynn, Miksh, Miksh. Carly's gonna go first? I'm sorry. So Carly, Megan's stepsister is gonna go first. Thank you. And Carly, if you can just spell your first name and your last name for the court.
Sure. First name is Carly, Carlie. Last name is Jerris, Joerres.
I see you're going to read something. That's fine.
Yeah.
A lot of people do that. Just read slowly.
Sure.
Okay?
Okay, thank you. Good afternoon. For those who do not know me, I am Carly. I am Megan's older sister. The amount of times that I tried to write, rewrite, throw away, crumple up, scream, cry, recollect my thoughts, and write again to make this impact statement for you today, I've lost count. But at the end of the day, that I hope my words can bring me peace and finally get things off of my chest, but also to give a proper insight to how much Megan meant to me. Megan and I had a 14-and-a-half-year age difference, so being in middle school and having such a younger sister, it was a challenge to help around the house while growing up myself. Watching her grow into the woman that she was, she inspired me to be a better person, be closer to God, and closer to my dreams and aspirations. She was the light of my life, and it wasn't until now until I knew that she was exactly what I needed in my life. Memories I will always remember of Megan will be waking up in the morning and getting her ready for school, trying to get the bird's nest out of her hair and try and put it in little pigtails, the way that she would wait for the bus super excitedly jumping up and down, excited that she would get to go to school with her big sister and ride the bus together. Even when I would get dropped off at school before her, she would always sit behind the bus driver and always say, "Have a good day, Carly." And she would give us a little handshake that we lasted until she passed. She would always watch Wonder Pets every morning as she would have cocoa coffee and her oatmeal. She was my best friend, and she still is my best friend. Even when I graduated high school and I moved away, I would still visit. Even when I was living in West Dallas and they were in Jackson and then moving right next door. As we got older, we didn't spend as much time together, and we had our ups and downs, just like any sibling would. But at the end of the day, I loved her unconditionally, and I would do anything for her. As we got older, we drifted away, but we always still remained in contact, texting, hanging out when we could, spending time together. I always supported her in sports, in anything that she wanted to pursue. I was always going to be her cheerleader, and even for her future of going to college out of state, pursuing whatever dream she wanted, I was going to be there for her. And then it came to a stop. Jason, not only did you take away a girl who had so much life ahead of her, you took away my baby sister. You took away a niece, a daughter, a sister, a granddaughter, a best friend. She was going to be in my bridal party. She was going to watch me get married to the love of my life. And that was taken away. She's never going to experience prom anymore. She couldn't walk in graduation or experience college. She doesn't get to be here with me as I start my new life, or be here when her brother gets to graduate high school. She won't ever get married, have her own kids, and have her own path for a bright and wonderful future that I know that she would have. I cry every day, I cry every night, I cry in the shower, I cry at work, I cry at looking at pictures of her in my wall. I cry at all the screenshots that are stuck on my husband's switch of her accidentally taking so many screenshots. I scream to the void, asking why is life not fair that her life was taken away so soon. I never wish this pain upon anyone. I have nightmares, I have breakdowns. What I would do to just be able to hear her voice one more time. Nothing I say now, whether it be directly to you or anyone, will be able to bring her back. I could scream profanities. I can sit here in a pile of hatred, wishing nothing but the worst. But if Megan were here, she wouldn't want me to do that. She would want me to pray for you. And in that, I will pray. I will pray that during your time, you think about her and you think about your life. I pray that every time you even stare at a liquor bottle, you think of her. And I pray that once everything is said and done, that you will think smarter about not getting behind the wheel while intoxicated again. I hope she lives rent-free in your brain because you took an innocent girl's life. But I pray that you learn from this while I sit here and forever grieve and pray that one day I can find peace. John 16:22. So also you have sorrow now, but I will see you again, and your hearts will rejoice, and no one will take your joy from you. Thank you very much.
Thank you, Carly. Good. Lynn? This is grandmother Lynn?
Yes.
All right.
I am addressing this letter to you, Jason. Since you didn't personally know my granddaughter, Megan Voss, I would like to tell you about her. Her life was priceless, not only to her family and friends, but to everyone who knew what a ray of sunshine she was, everyone who knew how special she was. I like to call her my angel on earth. These are some of the words to describe Megan. Loved God and was a child of God. Mature, confident, very intelligent but humble, kind, empathetic, caring, beautiful inside and out, loved by all ages, always smiling, gave the best hugs a grandma could ever want, and especially loved her family and her dog Blue. Now all I have left is a hole in my heart that will never be filled. I only have pictures of her growing up, videos, and memories. These are some of my memories I want to share with you. A tiny girl shoveling the snow off a deck with a pacifier in her mouth. A 3-year-old standing at the end of her driveway wearing a backpack and waiting for the Head Start school bus. Excitingly riding her bicycle without training wheels at age 4 or 5. Singing a solo of What a Wonderful World at a school spring sing when she was 5. Speaking to and hugging a 95-year-old woman at church every Sunday. Working nights at an Italian restaurant where she started bussing tables and worked her way up to hostess and still getting A's and taking advanced placement classes. Loving her work as a co-op student for several chiropractors. Her baseball teams, cheerleading, homecoming, and so many proms and prom court. Looking forward to beginning college in Arizona in a nursing program. Holidays with family. Family game nights. Her laughter, especially her laughter. This is what you have taken from me and my family forever. Never forget, you must be accountable for the consequences of December 30th, 2024. Your life won't be easy, but you will still have time to have a life, marriage, children, etc. Sadly, Megan won't. I hope you make use of any programs available to make you a better man. Megan would want that too. P.S. mainly for the judge. After more consideration, I have decided that 10 years in prison and 10 years of probation is not enough justice for Megan's short life. I would like the judge to consider 17 years, one for each year of Megan's life. Thank you.
Thank you.
And finally, we have a social worker who would like to provide a statement as well. And her name is Catherine, C-A-T-H-E-R-I-N-E, Callahan, C-A-L-L-A-H-A-N.
All right, go ahead.
Thank you, Your Honor. Thank you for allowing me to speak today. My name is Kathy Callahan. I'm the school social worker at Waukesha West High School. I have the honor, of working with Megan and her father for the past 2 years. Megan lived her life with gratitude, kindness, and love. Her smile would brighten the darkest rooms. Every person makes ripples in this world with every action they take. Megan's ripples were filled with love. When I would see her in the hallway, she would smile and say hello. Megan participated in activities at West to give back because she valued making the world a better, kinder place. Megan made a positive ripple when she decided to take a student with special needs to homecoming one year. She didn't do it for the look at me praise. She did it because she knew how much it would mean to that student. She brought so much joy to so many lives. I distinctly remember my last interaction with Megan. It was at a National Honor Society meeting in December of 2024. I had given her family something special with no expectations, and Megan came up to me at the end of the meeting and she said, thank you. Mrs. Callahan, your kindness means so much to me and my family. Megan was that kind of person. She lived with gratitude. She showed those around her all the abundant love in her heart. And I remember the day after she died, sitting there listening to my own daughter play her guitar and sing her music in her room, and I just started to cry. Because those simple moments were now never going to happen again for Troy. A parent should never have to lose a child, especially at the hands of a person's dangerous, irresponsible, and lethal choices. After the crash, I had the difficult and important task of supporting all of her friends and peers. The enormity of her death on the Waukesha West community cannot be measured, and it was humbling. I spent time with so many students who shared the positive impact Megan had made on their lives. Megan listened to her peers' pain and gave them comfort. If Megan knew a friend was struggling with a situation, she might bring them a Starbucks drink or hang out with them after school. The layers of impact on her friends are many. The first is that they struggled with day-to-day life. They struggled with sleeping, eating, focusing, and they cried a lot. They also struggled with their academics, and they didn't finish their high school year with the best grades because of their loss of focus and grieving Megan. Even her classmates were negatively impacted because they had to look at an empty desk, walk by an empty locker, drive by her empty parking space, daily reminders that Megan was no longer there. A death is not just a moment of grief and then we move on. It takes weeks, months, years, riding the waves of emotions. Megan's death has left a deep scar in her friends' hearts that will never completely heal. Now, Megan's life was not without her own struggles, but she always made room in her heart for others. The impact of her death on her friends will be lifelong. My only hope for them is that they will heal to a point where they can remember Megan and the smile. Perhaps they can make their own ripples of love to make the world a better place, as Megan would have done. The question I heard the most was why? Why would someone take such a kind, generous, and loving person out of this world? A question that had an absolutely pathetic answer of a stranger making a dangerous, selfish, and lethal choice. I shouldn't be here. I shouldn't know the name Jason Zehe. He should still be a stranger to me. And I don't know Jason or his story, nor do I care. Jason's ripples that night were based on a series of dangerous, irresponsible, and lethal choices that he made. We are here today because it's Jason's time to take accountability for his dangerous and lethal actions. Jason, .249. .249 is a number I hope you never forget. That was your blood alcohol level at the time of the crash. As a former drug and alcohol counselor, that number tells me this wasn't the first time you were drinking, and most likely not the first time you drove drunk. And let's not forget the pot, the cannabis that was found in your vehicle. Chances are that you may have been high that night as well. The fact is that the fact that this is not going to trial has already given you less than the maximum sentence for 4 felonies and 3 misdemeanors. Today is about you being given a sentence that is commiserate with your actions. Remorse? You may feel that, but is it true remorse for killing Megan? Or is it remorse for getting caught? I'm sure you will say the right things and perhaps even shed a tear for the court. But it's only with time that the true reason for your remorse will become apparent to you. And this is not a time to talk about forgiveness. Forgiveness is something that comes from the heart and must be given freely by the person who was harmed. Megan's family and her closest friends, they may choose to forgive you, and that is for them to decide outside the walls of this court and your jail cell. Your Honor, given that Jason is already going to have a reduced sentence because of the plea deal, I'm asking that you sentence him to the maximum amount of time that you can give him. Jason's actions and ripples took a bright, shining light from this world that can never be replaced. Thank you.
Thank you.
And I do note, I believe that there is another victim in the audience. I would just ask
Is
if
it a family member?
It would be victim B, I believe. If anyone else would like to give a statement, I'd ask them at this time if they'd like to give a statement. And she has indicated she does not.
Great.
Your Honor, I would just say that in terms of the third prong, protection of the community, that I think you've heard. Again, those are statements I could never replicate and give it a sentencing argument. But this is a pattern of behavior, and there must be accountability. And I would note that the social worker, Kathy, did indicate that there was also THC involved. There was a THC vape cartridge on his person, and also the lab report did indicate that he had marijuana in his system at the time of the accident. That's above and beyond the .249. Thank you.
Did you say there's another victim that we want to hear from now?
Well, there was a victim that I saw sitting on the defense, victim B, and I just asked her if she wanted to give a statement. She has indicated she does not.
I misheard you. I'm sorry.
I'm sorry.
All right. Mr. Stanley.
Judge, first of all, is any statement that I make on behalf of, obviously, the defendant is not to take away from Megan, obviously, but under the law, you have to take into consideration who the defendant is, his background, and the facts and circumstances why he's sitting in court here today. So it's not to take away from Megan at all, to say this is all about him at this point. It's not about him. It's about what his punishment should be with regard to that. And Judge, like I do in most cases, I find out in like cases in Waukesha County, and there's been 7, if you will, in the last, well, going back to 2012, but then really 2017, there's been 6 of them. Just looking at the averages of what happens. Some of them are, a couple of them are a low. One is just 2 in and 4 out for a 17-year-old friend that was killed as a result of it. Then there's one with 14 in and 10 out. There's 2 with 6 in and 8 out, and 1 with 7 in and 10 out. So the last one, the most recent one, Judge, in 23 was 10 in and 10 out. So the recommendation by the District Attorney's Office is what is, if you will, a reasonable sentence within what happens in the county. However, obviously there are some lowers, and I'm asking the court to consider 8 years, only because I think that the 8 years in and 10 years out, only because I think that Jason Judge has gone above and beyond the call of duty, if you will, is in order to make his wrong actions right the best that he can. When I say that, Judge, is he didn't have to sit down and talk with the civil attorneys. He did not have to make a statement. He, as you know, he has a constitutional right just to sit here and not say a thing. And from day one that I got into this case, Judge, in January, here he is 7 months later, taking full responsibility, not even pleading no contest, he's pleading guilty because he is guilty. And regardless of that, judges, he would do anything in his power, obviously, to try to right the wrong that he created. And it's his conduct that brought him here. There's no question about it. But I'll get into the facts and circumstances, as Ms. Basie did, why we're here. I can tell the court that you know from the plea questionnaire, Judge, he's 19 years old. He's a lifelong resident of this area, Judge. He went to high school, as you've indicated in my sentencing memorandum, Judge, is that he graduated early. He had all AP classes, very intelligent young man. Didn't want to go to college. He had a scholarship because he wanted to go into the trades. He wanted to become an electrician. And he was studying in an apprenticeship to become an electrician, Judge. He is single, he has no children. He's been with victim B, who's in court here for the last 4 years. He was working, Judge. He was working at the time. He had multiple jobs, as indicated in my sentencing memorandum, but recently, Judge, he's had several jobs in the electrical field, latest being Wilkie Electric in Big Bend, which obviously that was his passion, honestly. He wanted just to be an electrician. That's what he wanted in his life. His mother and dad are not together, Judge, but they're both in court today. They're both very much on the same page. When I say that, it's just because they're not together does not mean that they're not on the same page with regard to both his upbringing and other siblings' upbringing, Judge. They're very much in support, but as you read from the letters, there's a history of abuse in both of them and readily admitted to it. And I don't know whether, and we can argue until we're blue in the face, as to whether or not the defendant's alcoholism and his AODA issues are a result of being hereditary or learned behavior. I don't know the answer to that, but clearly that contributed to this. What also contributed, Judge, is, as Ms. Basie said, that maybe there were these other incidences, and I say maybe there were the other incidences, but her words were the accumulation of these incidences puts him here. I take it one step further, Judge, is that they were all contributed by victim B's family and her mother. How, in that statement, if it's believed, and there's no reason to not believe it, Judge, is he has drank to excess in that house over 100 times over the last 4 years, since 15 years of age. What adult allows 15, 16, 17, 18, 19-year-olds in order to honestly drink to excess and allow them to get into a car and go? I can't fathom an adult doing that and allowing it to happen. And the incidents that Ms. Basie said is what is the common factor in all of that? It's the mother feeding them alcohol every single time. And what's even more outrageous, Judge, is that since this incident, victim B has picked up another drunk driving where she was drinking with her mother at home and had to go to WCTC and cracked up her car and has an OWI case. They still don't learn. I just don't, I'm not taking away from the defendant's conduct. He is criminally responsible. There's no question about it. But he's 19 years of age, Judge. They say that the young man's brain is not even fully developed until 25. And you're being fed this by an adult, and then dad comes home because he gets upset because mom's giving the liquor to the kids, and he gets upset on more than one occasion and kicks them out and tells them to drive, get out of my property, leave here. Doesn't say, go call somebody. Doesn't say, call the cops and say, this kid's drunk and drinking in my house. Nothing like that. And as a matter of fact, when he cracks up the car and puts him in the cornfield, and both of them, they cover for him. Absolutely cover for him and hire a lawyer for him. The judge, it's conduct that is just unbelievable to me that something like this is happening. And of course, we're in court right now because an adult didn't stop it. And again, I'm not trying to take away from what he did. He did, and he's taken full responsibility. From day one in January when I talked to him, Judge, he wanted to plead guilty. He just wanted to come in and plead guilty to every charge if necessary, but that's not how the cases go. I mean, I have to investigate the case, but I do have to say that in all these cases that I've done in the 40 years, this is probably about the quickest plea. And it's because I was able to look at the facts of the case. I was able to look at his defenses. I was able to sit down and make sure that the car was functioning properly, which would have been a defense of the car. And at the end of the day is he's here accepting his responsibility. And I did put in those skid marks, Judge, and I'm not denying the fact that the truck was going 66 or 69 miles an hour, whatever it was, Judge, but it's an old farm truck. It's an old heavy truck, and he did try to skid. He did try at the last minute to stop, but it just took a lot for that car to stop. And unquestionably, Judge, Ms. Basie indicates that the car very well could, or the truck very well could have been going faster. I don't know the answer to that because obviously we don't have the science on the weight of the car and everything like that. But the long and short of it is he did try. There's no question he tried. But again, he should not have been behind the wheel with regard to it. He's a young man, Judge, with no prior record. He does have the OWI that was dismissed. It's gone into, I'm not going to beat a dead horse on that, but he has no prior record, at least a criminal record going through the system. I don't believe he's a violent person. He does have a pattern, if you will, of maybe you could say criminal activity of drinking and driving. There's no question about it. But again, it's brought upon by an adult who's feeding him and sending him on his way with regard to it. So clearly not an isolated incident, and there's obviously, we're in court today for that conduct and series of conducts with regard to it. But again, Judge, I can tell you that he's accepting responsibility from day one. He has always said that he would be held accountable for it, and he will. I think what his attitude, Judge, is I need to obviously work on myself and get myself better too. That's why I indicated all those certificates and courses that he's done within the jail. And people can say you're just doing that to make you look good in front of the judge. That's not true, because I have all kinds of people that have been incarcerated that don't do a thing. They just sit in a cell day after day after day. And he indicates that, in fact,
for some reason you unmuted Ms. Voss. If you want to mute, there you go.
Well, in prison, and clearly he knew from day one that he was going to prison, but his attitude is, how can I make myself better in prison? And he continues, if you will, he will continue in his apprenticeship and hopefully within the prison system. So, Judge, I'm here to say that he's extremely remorseful. You've read his letter with regard to it. I don't know if emotionally he's going to talk today or not. But I can tell the court that I believe that he is the personification of acceptance in a case like this, and that's why I'm asking for the extra, if you will, the 8 years instead of 10 years, because I don't know that I've ever had anybody accepting responsibility as much as he has and as cooperative as he has in this case, both with this case and the civil case. His actions warrant a prison sentence, there's no question. But I can tell the court that he can conform his conduct to the requirements of law. I think that the conditions of his supervised release and the probation that is recommended to you by the state with those conditions, Judge, he can prove to the court that he has the capacity to live with those. If not, obviously he'll go back to prison for 10 years if he can't do it. But he's got the motivation to become a better person, a more productive person, Judge. He's got the intelligence, as he indicated, extremely smart young man. He just needs to stay away from negative influences, obviously, victim B and victim B's parents, and that whole, if you will, the party and attitude that young people have nowadays. He's made a conscious effort, Judge, to change his life. Obviously, the felony is going to impact his life for the rest of his life. He has serious, if you will, supervised release needs as well as probationary needs. I just don't think that, honestly, an 18-year sentence, and I'm recommending Judge will unduly depreciate the seriousness of this case. So in all those instances, or I'm sorry, I lost my train of thought, but I'm
given those factors.
Yeah. I'll start over. As Judge, what I'm trying to say is he's just a young man leading kind of an unfocused life, but you would think that there would be focus with the people in his life in the case, and it wasn't, Judge. So for all those reasons, I'm asking you to sentence him to the 18 years as opposed to the 20 years. Thank you.
Mr. Zehe, you have the opportunity to address the court before I impose my sentence. Is there anything you'd like to say?
Yes. First, I'd like to start by saying I'm sincerely sorry. There aren't enough words to say how sorry I truly am. My actions the night of the 30th were unexcusable and irreversible. I lay awake every night wishing things were different, wishing it was me who passed and not Megan. She didn't deserve anything that came to her that night, and from all I heard, she was an amazing young woman. Sorry. I hope the family can grieve knowing how sorry I am. I hope that they get the closure today that they 100% deserve. I've lost family, but never in such an abrupt and tragic way. I can only imagine how sad, confused, and plain angry all of you are. My heart goes out to all of you, and the friends, the family, and all of Megan's loved ones. You're in my prayers daily. I know I can never right this wrong or bring Megan back, but I will work night and day to prevent it from happening again. Nobody should drink and drive, and everybody should know the consequences. I'm not asking to be forgiven today, because I can't even forgive myself. All I ask is you know how truly sorry I am. That's all. Thank you.
Judge, as far as sentence credit, he has 235 days of credit.
Any objection to that?
I think it's 234. We don't count today if he goes to prison.
Oh, no, that's mine. That's
234.
Yeah, I did count today, so she's right.
I read all the submissions, and the facts are pretty straightforward. December 30th of 2024 at approximately 7:25 p.m. in the city of Waukesha at the intersection of East Sunset Drive and Guthrie Road. The officers that showed up observed 3 vehicles that had crashed, including a white 1994 Audi, a silver Toyota RAV4, and a white Dodge Ram truck. The most significant damage was to the Audi, and it was the entirety of the driver's side of the vehicle. Piecing back in the facts of that day, as they were later developed, Mr. Zehe was scheduled to work as an electrician, but he decided to call in sick because he wanted to start New Year's a little bit early. And so he went to his girlfriend's house and started drinking wine before noon until they ran out of wine. And then they saw what else they can find. They found a bottle of vodka, and they started drinking vodka. And then victim B's father got home and said, "You need to leave." And he left. Drove away in his car. Came back when he got texted by victim B and said, "Come back." Victim B gave a statement about all that, what I just talked about. According to victim B, the defendant was driving around the city and a sedan was driving next to him, and he was beginning to race that sedan and going approximately 50 miles an hour on a 35. That's according to victim B. Obviously, we know some of the more detailed facts. We heard from victim C, who witnessed this uninjured and gave a statement at the time that the white Dodge Ram pickup truck was going eastbound on Sunset Drive very fast and flashing his brights as if to alert people to get out of the way, that he wasn't intending to stop. The Audi was going northbound in Guthrie, stopped at the stop sign and started to proceed through the intersection. Victim C, Donald, noted that it was the Audi's turn to proceed through the intersection. Victim C realized the Dodge Ram pickup was not going to stop. and he observed it crash into the Audi. In the discussions, as it was talked about by the state, Mr. Zehe first lied, saying he wasn't drinking. He did state that he was at his girlfriend's parents and he got drunk, and they knew he was drunk and they forced him to leave. There was also a THV vape located in the back of his pocket. His BAC was a .249. A lot of these facts come from the complaint. Some of it comes from other statements and submissions made. The most difficult and chilling statement, when I read the complaint, is at approximately 9:07 p.m. on December 30th. Officer R. Krause was advised by medical staff at Freighter Hospital. They had stopped life-saving efforts as victim A had succumbed to the injuries she sustained as a result of the defendant crashing into her vehicle that evening. Mr. Zehe is guilty of homicide by intoxicated use of a vehicle. It's a Class D felony. The maximum sentence is a bifurcated sentence of 25 years in prison, 15 years of initial confinement, and 10 years of extended supervision. He's also guilty of second-degree recklessly endangering safety. That's a Class G felony. The maximum sentence is 10 years in prison, 5 years initial confinement, 5 years of extended supervision. I'm obliged under the law to impose the minimum amount of confinement necessary to satisfy and address these three factors: the protection of the community, the gravity of the offense, and the character and rehabilitation needs of the defendant. When I first became a judge, one of my colleagues says it's the three C's. It's the crime, the criminal, and the community. The first consideration, generally probation. No one's talking about probation in this case. These basic facts and legal principles recite what happened and the crimes that occurred that night, but they do nothing to outline the tragedy impacting the lives and families of those involved in the crash. The submissions help me understand what really happened, the impact to the family, the loss, and it's only in this way that I can truly understand the gravity of the offense and the crimes. Who was Megan? I read the impact statements, and a lot of the words that jumped out that several people used, and I don't think there was any coordination among anybody. Angel came up a lot, and it was used today. I heard from Catherine and Rick, who Rick was a pastor at Megan's church, that she was eager for church activities, that she would go to church on her own. Even if she couldn't get a ride, she'd ride her bike to church. And their child was fighting osteocarcinoma, bone cancer, and she was a companion to him. And they both say they want the maximum sentence. Justice served to the fullest extent. I heard from Ava, who's a friend. She said, grief creeps into the quietest corners of my life. The memories that used to bring joy now sting with unbearable absence. This jumped out at me. This was unexpected and preventable. She said, there are no words strong enough to explain the pain Megan's death has caused, but I hope this statement helps you understand even a fraction of it. I hope it makes it clear that the choices made that night did not just take 2 lives. They shattered dozens and continued to do so. And if justice means anything, it should mean doing everything possible to make sure this never happens again. I heard from Aunt Jilly, who called her an angel. She was the brightest light in my life since the day she was born. We'll be reminded of her absence on every holiday and family gathering. We will struggle between celebrating and grieving. He stole her high school and college graduation, her career, her wedding, her babies, and all of her birthdays. He stole tremendous light and love from this world. So in my heart, I believe he deserves the maximum sentence allowed for each charge. One friend just submitted something anonymously, didn't sign it. Megan had a voice you could hear and know who it was, and it carried weight even though she physically didn't. Everyone says actions speak louder than words, but for Megan, her words spoke in volumes with her actions. In times when I hung my head low or turned away from a crowd, Megan was there to ensure your head would rise by the end of the day. She left no soul untouched when she passed, as she would always greet anyone she'd meet, asking them how they were. You couldn't help but open your heart to her as she wore hers proudly on her sleeve. I heard from Haley, who said she would have been a great mom, a great aunt, a great nurse. She would have been amazing. But you took away someone's future. You took away so much of people's happiness, all because you chose to be reckless. Kai said she was the only person who I could say was genuinely kind to others without wishing for anything in return every single time. Tara said, now when I go forward with my life, I go to events and think to myself, she's supposed to be here right now with me, my partner in crime. But whenever I think about it, I know that Megan would want me to be happy, to tell her story as the girl who was the kindest person that you'd ever meet, who would go out of her way to make you smile, or even stop the congested flow of the hallways during passing time at school, just to walk across the hallway to walk with me to our next class. Ryan acknowledged he was going through lots of tough times in his life and turned to Megan for help. He said Megan was a great person, and to be honest, as close to an angel as I think anyone can ever get. She always was willing to help other people, even if she inconvenienced herself to do it. This was one of my favorites. Brenna talked about attending Mamma Mia at the drive-in last summer. At some point, Megan jumped out of the car at the first note of Dancing Queen, and reaching for my hand to join her, she swayed and twirled to the rest of the song, Not a Care in the World. Her absence has left many with a hole in their life. I know the pain of losing a friend will never be eased, but it will bring so many people relief knowing that justice has been served. Brenna's father said she had a laugh that filled a room, a heart that made space for everyone, and a future so bright. Her life mattered, and so does the justice we seek. Please sentence Jason Zehe to the maximum allowed by the court. Heard from Lauren, who said Megan was happiness in human form. She volunteered, was in many clubs, but most importantly, her kindness touched so many lives. She wanted to go into the medical field in hopes to help those in need. That was just who she was, someone who cared deeply for everyone around her, someone who listened, someone who wanted to heal the world, no matter how big or small of an impact it was. I can only hope that her story is heard by many, and hopefully this will stop people from getting behind the wheel while intoxicated. Of the 7 that you talked about, Mr. Steinley, that have happened in this county in the last years since 2017, 2 of them were mine. And they're the toughest cases I've ever had, just like this one is. And the letters that I hear from the victim's family are very reminiscent of the letters that I hear today. They want justice. They want to fill a void in their life because they have suffered such an extraordinary loss. The void, that hole, any loss of a loved one leaves that void. But the void is greater when the loved one is taken unjustly, untimely, unfairly. It's what Ava said. This was unexpected and preventable. That's what makes the void so hard to fill. Many people think they can fill the void by receiving justice from the court. They ask for justice as a form of healing to help them recover. There's some truth in that. And I hope my sentence and disposition of this case can provide some form of closure for the family that the funeral practically couldn't give because of the pendency of this case. But what is justice? Many victims harmed by criminals believe that justice necessarily is the maximum sentence. Anything less is a travesty. They believe that the more punishment the criminal receives and the more the criminal suffers with my sentence, the better they will feel. It will heal their pain, fill their great void left by the loss, and brace them for a future without their loved one. I submit that a sentence predicated upon punishment and revenge has little chance of filling the void. The best way to fill the void is to structure a sentence that honors the memory of the person lost. With your help, I've gotten to know Megan to a certain extent and the type of person that she was. If Megan can come down and advise me what justice requires in this case, what would she say? Would there be no mercy for Jason? If she was here guiding me in this difficult decision, would she want the maximum sentence permitted by law? And again, I've heard from you. I've heard from some of the people today. I heard from Ava. Megan was an incredibly forgiving person. If she were here, I believe she would forgive Mr. Zehe, but she also would demand change. Kai said, to hate someone is a disrespect to Megan's goodwill and character. If she was still around, I know that she would forgive him, and it makes me realize how much I still have to live up to her memory. I want to hate him, but Megan's memory will only allow me to forgive him. And I hope that everyone who has been affected this will find a way to forgive him as well, for Megan's sake. Ryan, I kind of close with this from Ryan. Because her life was cut short, I need to honor her and follow in her footsteps, even though it's hard. The hardest part, I think, is forgiveness. I don't want to forgive Mr. Zehe for what he did to someone I cared so much about, but it's what Megan would have done, so I want to as well. I believe in second chances, and I know for a fact that Megan did too. So, Judge, when it comes to sentencing, don't be too harsh. Give him what he really deserves, not extra, because of the pressure of others' emotions. To all you suffering from the loss of Megan, I hope you will find my sentence just, and to the extent any words of mine can console you on a loss so overwhelming, at least it might help you achieve closure and begin the process of filling the void you feel. I next turn to the defendant and to his character and rehabilitation needs. In a very real sense, I must bear in mind that 2 lives were lost that day. Megan's life on this earth and the life that Mr. Zehe had and knew up until December 30th of 2024. That life is, for all intents and purposes, forever gone. He has a new life, that of a convicted felon responsible for the death of a loving and beautiful person. What that new life entails depends in part on what I decide today, but more importantly on what he decides to make of it. At the time of the collision, Mr. Zehe was 19 years old. He was not of legal drinking age, yet his blood alcohol concentration was 0.249. That's grossly high. It's grossly high for anyone at any point in time. It's grossly high to a 19-year-old in particular, and it's obscenely high for anybody driving a vehicle. He had no prior record. Concerning for this court, however, is that he did have the 2 prior incidents that the state talked about, where he had shots across the bow to warn him that this is a real problem. One time where apparently on February 5th of 2024, he ends up in a ditch. But more importantly, the one from April 4th of 2024, where he crashed into the pillar, drunk, with a .17, charged in court, facing consequences, and then gets off because he wasn't driving on the road. Now, that's not a technicality, that's the crime. The point is, that should have been the wake-up call for him. That's where he should have realized, what am I doing? Why am I putting myself at risk? Why am I putting others at risk? His own submissions talk about the many times prior to this that he consumed up to 100 times. I reviewed the sentencing memorandum from Mr. Steinle. Thanks for that. I appreciate getting those ahead of time, what you're going to be arguing, so I have an idea. I also received the 31 courses and the certificates of all the work that he's been doing in the jail for the last 230 some odd days, which is a lot of courses that he's been doing. He's putting his time to good use, frankly. You talked a little bit about the other parents and the blame. And I'm not going to talk about that because there may be an open case regarding that. But I can say this, no one forced him to drink, and no one forced him to get in the car and drive. And if he was kicked out of that house at that time, and I understand the circumstances of all that, I would be pissed if I was dad, too, and the same punk is in my yard. The guy just smashed up my pole. Now he's here again, after I told him not to do that. I'd be mad, and I may say leave, maybe in anger, but it's his decision to get in the car. He could have called an Uber. He could have said, no, can you drive me? There's lots of things that could have happened to avoid the situation, and he just didn't do it. I read the character letters, there were many character letters that were submitted in support of Mr. Zehe. Family members consistently shared with me what a thoughtful and hardworking young man Jason is, and the remorse Jason feels for what he has done, and he's accepting responsibility here, as Mr. Steinle mentioned, very quickly in a significant case like this. Crystal, his mom, stated, I've been doing everything I could to stop the generational curse of addiction within our family. After the first incident that was dropped, we talked about it in depth, and I never expected he would drink and drive again. Again, that's a reasonable assumption that after something like that, dodging the bullet, you wouldn't put yourself and anyone else in that position again. His dad shared with me that he was brought up with a strong Christian influence, which I know will help him realize what he needs to do to grow and honor Megan to the best of his ability. His stepmom, who said maybe they had some issues in the past at times, which is often the case with having a stepmom or a step-parent, said he is so smart with so much potential and believes he'll use this tragedy to improve himself and live a life that will honor Megan. His grandparents, I heard from his grandparents, 3 of the grandparents, they spoke to his work ethic, his respect, and most importantly, the remorse that he had over his actions. His aunt, Nicole, stated, I pray that his time in prison is used to continue to complete courses and attend any groups available for alcohol substance abuse. I hope he prays to God, asks for forgiveness, and prays for the family and friends of Megan, as I cannot imagine what they have been through since her death. I heard from 3 of his brothers, including Eli and Dominic, who are pretty young. One of them, I think it's Eli, spells horribly, and his writing is the worst handwriting I've ever seen. They just talked about how he plays with them, and he helps them. His other brother, Parker, who's older, but still he's younger, older than Eli and Dominic, but younger than Jason, stated he wasn't just my brother, he was my best friend, my confidant, and somebody I looked up to. My brother has a good heart, good morals, and the potential to do great things in his life. I understand that there must be a punishment for what he did, but pray that the court understands this is out of character for him and give him another chance to redeem himself. Friends and neighbors expressed how Jason has been there for them and is generous, kind, and helpful, and hope that the court will take his character into account in my sentence. We heard that his landlord, Mary, submitted something, and there was a quote from that. The quote that I'd like to read from Mary was that she hopes that I give community service included in the sentence because that'll be a positive impact by speaking to high school kids about tragic consequences of drinking and driving. And I heard from Tom Pippins, P-I-P-I-N-E-S, who's with the jail ministry and been doing some of the work with Jason while he's been in there. He states, I believe that he would like to make amends to the young woman who passed away too soon and to her family by living his best life and becoming a contributing member to society. It is my hope and prayer that judgment can be accompanied by mercy. And again, in these cases where I have these difficult decisions, I hear from the victim side and what they want, and sometimes it's the maximum sentence to fill that void, and I hear the other side asking for mercy on behalf of a loved one. Mercy without justice is just as bad as justice without mercy. It suggests there's no accountability. Finally, I reviewed a letter from Jason. In that letter, he accepts full responsibility and expressed his deep remorse for his actions, understands how his actions have left a dark abyss in this community, his words, but vows to help others see how wrong drinking and driving is. He states, I will never forget and I'll never forgive myself. The last factor I need to talk about is protection of the community, what's going to take to protect the community. There's two factors there that I deal with. Usually it's a general deterrence. How do I protect other people from doing this? Sometimes it's sending a good sentence out there, a difficult, strenuous sentence. So people know if they do something like this, there's a very significant consequence. That's the general deterrence. Then there's also specific deterrence. How can I make sure that Jason doesn't do something like this again? And that deals with his rehabilitation. A sentence that doesn't hold him accountable will not aid him in overcoming his grief for having taken the life of an innocent victim. It will not address his guilt. A guilt so overbearing can only be addressed by a sentence that incorporates an appropriate degree of accountability and punishment for the crime he committed. A sentence that does not do that will, I fear, doom Jason to a guilt-ridden existence from which he will never recover, as his own letter makes clear. I hope and pray that the sentence I impose addresses all these factors: justice, mercy, accountability, punishment, deterrence, rehabilitation, and protection of the community generally. Based on all those factors and all the other factors I'm obliged to consider under the law, here's my sentence. With respect to count 1, 10 years of initial confinement followed by 10 years of extended supervision. With respect to count 4, 5 years of initial confinement followed by 5 years of extended supervision consecutive to count 1, imposed and stayed for 5 years of probation. Conditions of extended supervision and probation, iota assessment followed with any treatment recommended. Absolute sobriety with random screens, no use or possession of alcohol or controlled substances without a valid prescription or any drug paraphernalia. Any valid prescription drugs must be taken only in the manner in which they are prescribed. Inform your agent of all prescriptions. Follow through with any treatment or counseling recommended by the agent. Full-time employment or combination of schooling. No contact with victim A or victim A's family. No contact with victim B or victim B's family. No contact with victim C. DNA sample and surcharge. No association with known drug users or dealers, and no contact in any place where illegal drugs are purchased, used, stored, packaged, or distributed. No presence at any establishment that serves alcohol by the glass. No operation of a motor vehicle without a valid driver's license. $200 hours of community service performed at the direction of the probation agent. That may be speaking at victim impact panels, which are a very beneficial thing we have in our community, to let people know the consequences of their actions. And I think that would be a way to honor Megan to make sure this doesn't happen again. Including that community service to the extent possible, 8 hours that will be served on December 30th of every year. He's on extended supervision and probation. There's 234 days of credit. Are you stipulating to restitution?
I am, Judge.
Restitution, the amount of $12,077.09 to the estate of victim A or victim A's?
Victim compensation.
Victim compensation, thank you. And Court cost, what's that come to be?
Total amount $13,113.09.
Court orders that all restitution, surcharges, court costs, and fines shall be collected by the DOC while defendant is in a state prison and as a condition of extended supervision. Collection shall be at a reasonable percentage determined by the DOC. Having been convicted of a felony, I need to advise you may not possess a firearm at any time in the future. Section 941.29 of the Wisconsin statutes makes it another felony for anyone who's been convicted of a felony to ever possess a firearm, carrying with it its own 10-year period of imprisonment or $25,000 fine or both. Having been convicted of a felony, I must advise you cannot vote in any election unless and until your civil rights are restored. Other than appeal rights, am I leaving anything out, Ms. Basie?
No, Your Honor.
Mr. Steinle?
No, Judge, and
I have one other, hang on. Programming?
I don't believe he's statutorily eligible.
I don't think he's eligible either.
I don't think he's eligible, but good to ask. Thank
Yes.
you. I'm going to close on one person we did not hear from, which was victim C, Donald. He submitted a statement. He was a witness to the accident. His vehicle was damaged. He was uninjured, thankfully. And this was his prayer. I pray that you never forget what brought you to this point, that the weight of your actions stays with you, not to destroy you, but to change you. I hope you seek God's guidance through the journey ahead, because through him there is still hope for accountability, for redemption, and for transformation. That's my prayer too. You have 20 days to appeal this decision or seek any other post-conviction relief. You're going to fill out a form with your attorney and get that on file, Mr. Zehe. Good luck.
Welcome to the Deep Dive. Today, we're tackling a really tough topic, the Jason Zehe sentencing.
It's definitely heavy.
Yeah. And this isn't just about the final legal decision. It's more about, everything that surfaced in the courtroom, judicial thinking, legal tactics, defense arguments, and just the raw, changing face of grief.
Mm-hmm.
We've gone through a lot of material analyses, court statements, victim accounts, and our aim here is to sort of peel back the layers on this incredibly impactful event.
Mm-hmm.
How does the justice system actually handle a situation where, well, perfect justice feels impossible? Okay, so let's dive in. Judge Abrahamian's approach was, well, quite striking.
It really was.
This wasn't just checking boxes in a sentencing hearing. He turned it into this deep reflection on justice itself, constantly asking, what would Megan want? He didn't just skim the victim letters, he clearly absorbed them. He was quoting specific things like her jumping out of the car to dance to Dancing Queen from memory.
Yeah, that's what's so fascinating, isn't it? How he made Megan real, a whole person right there in the court. It really sets the tone. It shows what judicial wisdom looks like under immense emotional pressure. It's like watching someone grapple with this impossible task. How do you put a number, a sentence, on a loss that can never be replaced?
So then we look at the prosecution side with ADA Leslie Bose. She also brought a human touch, asking to use Megan's first name.
Mm-hmm. Which is significant.
And crucially, presenting that pattern evidence from 2024, the reckless driving back in February, then the pillar crash in April that really shut down any argument that December 30th was just some isolated out-of-the-blue thing.
Definitely.
But then there's the plea deal. They dismiss several charges.
Yeah.
And you have to ask, maybe, did they give up too much ground there?
That's a fair question. Legally speaking, getting a guaranteed conviction is often the priority, a pragmatic choice, maybe. But yeah, with Zehe's history, that pattern you mentioned, and the fact that the system arguably missed a chance back in April, did they maybe have the leverage to push for more? It highlights that tension, between practical legal strategy and maybe what the community sees as full accountability.
Okay, on to the defense. Attorney Steinle had a tricky path to walk.
Very delicate.
He brought up the role of the girlfriend's parents in providing alcohol to minors. He framed it as context, trying hard to say it wasn't an excuse.
Right. Context, not justification.
And then he used data from similar cases where sentences ranged from 2 to 14 years to argue that his request for 8 years was actually pretty reasonable compared to the prosecution's 10-year recommendation. Then you have the victim impact statements. Just a powerful, raw display of grief in all its forms. Megan's sister, Carly Shores, shared her loss, but also gave the judge this incredible moral anchor, saying Megan would want her to pray for Z.
That's powerful.
Then the grandparent, Lynn Mix, showed how grief changes.
Yeah.
Initially accepting the plea, but then asking for 17 years. And Catherine Callahan, a former substance abuse counselor, she brought this professional view, stating that a .249 BAC suggests habitual heavy drinking. And she directly questioned if Zehe's remorse was real.
Yeah.
Z's own statement, his allocution. It was hard to read.
Definitely open to interpretation.
Saying he wished he died instead of Megan.
Yeah.
Was it genuine? Performative? We can't know. And it was short. Shorter than any victim statement, which also kind of leaves you wondering.
And all those statements from Zehe, from the family, that just really highlight how much these personal stories and evolving feelings shape the whole legal process. The court has to weigh all this subjective experience. It's incredibly complex.
So, okay, stepping back, what does it all point to? Well, it definitely exposed some systemic issues.
Big time.
That private property loophole that got Zehe's April OWI dismissed, that directly removed a chance for intervention that might have prevented Megan's death.
A critical failure point.
Plus, there were signs throughout 2024 adults enabling underage drinking, neighbors seeing warning signs, but maybe not enough being done.
Yeah, connecting that to the bigger picture, right? It shows how community awareness is one thing, but without effective ways to intervene, dangers can just keep escalating until tragedy strikes. It really speaks to a kind of collective responsibility.
And we also need to mention the silence. What wasn't said.
Right, that was powerful too.
Megan's father and brother chose not to speak, saying their grief was just too deep for words. Victim B, Zehe's girlfriend at the time, she also declined, and Zehe's parents were silent. That silence itself felt heavy in the room. So the judge lands on the sentence, exactly what the prosecution asked for. 10 years initial confinement, 10 years extended supervision. It showed judicial restraint.
A middle ground.
Exactly. He found this principled middle path. He used the sister's words about prayer and forgiveness to argue against the maximum sentence, but he used the sheer gravity of the crime to justify not going lower than the recommendation.
And the structure of that sentence is interesting too.
Yeah, quite creative. Part of it is stayed, suspended, and there's this requirement for 200 hours of community service, specifically to be done around December 30th each year. It tries to turn that awful anniversary grief into something potentially preventative. It's thinking beyond just locking someone up.
A different kind of consequence.
So ultimately, this deep dive, I think it shows the criminal justice system kind of at its best, but also bumping up against its absolute limits.
Yeah, I agree.
The process felt fair, it was thorough, people were heard, or their silence was respected. You could feel the judge wrestling with the decision.
Absolutely. But that fundamental truth remains, right? No sentence, no matter how carefully considered, can bring Megan back. It can't completely heal her family, and it can't guarantee Zehe is redeemed.
Yeah.
What we saw was probably the best possible response the system has for a situation where true restorative justice just isn't achievable.
So this deep dive doesn't really give us easy answers. Instead, it leaves us with, well, a much more complex picture of how our justice system tries, and sometimes struggles, to deal with immense moral harm. When a life is gone, what does justice truly mean to you? Thanks for joining us for this deep dive.
I was built to last with the webs I'm weaving. I could change the past with all I'm achieving. Got my foot on the gas, never stop competing. If you break my glass, then this life's gonna end.
I wanna be the best in the game, invest in my name. Check no restraints, I'm obsessed with the pain. I ingest, I retain, assess and I change. Possessed by the thought I'll be free one day from society's restraints. Money, clout and fame, mud, disease, a plague. We all love to hate, have to play the game, have to make a name. All our insecurities are on display. This is war with the enemy, think that it was meant to be. Living in a time where disease is on every screen. I won't let them fester me, I know most are festering. Negativity is a plague for the mentally weak. No mercy, all I got is working. Never stop searching, never quench the thirsty. I'm toxic and psychotic with this logic, you can't stop it. It's been chronic since I was a boy, so neurotic and chaotic.
Built to last with the webs I'm weaving. I could change the past with all I'm achieving. Got my foot on gas, never stop competing. If fast, life's gonna eat 'em. Make mistakes real fast, then you learn how to beat 'em. If you take off the cast, you can see all the healing. If the pain's in the past, move on from the grave and put your foot on the gas. No, never stop competing, yeah.
I've been doing this, I'm on it. I just wanna be iconic. Sipping on a gin and tonic, got me going off when I'm on this topic, yeah. If I ever play, I want it. You know that I'm always honest. Stay away from those who are toxic. Keep 'em out your face, no way, you don't want it, yeah. Don't try to drain my energy. The enemy is everything. It's mentally, unhealthily, spreading like a rare disease. But I won't let it get to me. I don't need your therapy.